This program only reflects the personal views of the program host and all the individual contributors.
Good evening, this is Newsline. I'm Michael Chagani. Tonight, consumer rights and the monopoly of big companies. With me is Greg So, the Undersecretary of Commerce and Economic Development. Thank you, Mr. Greg So, for being on this show. I think this is the first time you're on this show as a political undersecretary, yes. Right? Before you came here as a member of the DAB political party. Now you're a political undersecretary with the Hong Kong government. Thank you for being on the show. Now, you're handling two very important pieces of legislation. One is still a proposal, the other is going through the Legislative Council. It's not been getting a lot of publicity, but they are very important issues. One is consumer protection, and the other is a competition law aimed at breaking up monopolies in Hong Kong, or aimed at encouraging competition in Hong Kong. Now, these two laws are really very closely linked, aren't they?
They are interrelated. First of all, we have the consumer protection consultation, and that's about unfair trade practices. We want our trade to compare fairly and consumer to be protected. And the other is competition bill. Of course, competition is good because it would be enhancing the economic efficiency of the market, and consumer will benefit. So the two are related. But I want to make it a point that the competition bill is not to deal with monopoly. In fact, we do not regulate market structure. We target anti-competitive conduct, and that's the main purpose of the bill, that there would not be anti-competitive conduct that would prevent, restrict, or distort competition.
Well, explain this to me, Mr. So. You say it's not going to deal with monopolies, but your target is to have anti-competitive products. In other words, you don't want products out there to be not
anti-competitive conduct. Yes.
All right, conduct. Okay, so you don't want people or companies in Hong Kong to be anti-competitive, right?
That's right.
But surely, isn't that the same thing? If they are anti-competitive, they become monopolies.
Well, actually, there is a distinction, because that we're talking about market structure or market. About the mere possession of market share itself is not the problem. What we're dealing with is anti-competitive conduct. For example, if it prevent or restrict or distort competition in Hong Kong, that's when we stepped in.
That's when monopolies do that. That's what I'm trying to say. It's monopolies
the law
that do that.
Deals with these anti-competitive conduct by way of the bill has already been tabled. There will be two general conduct rules. The first one deal with agreement, decision, and concerted practice. And the second one deals with abuse of substantial market power. If these conducts would have the effect or the object of preventing, restricting, and distorting competition, that's when the law will come in.
Okay, well, you know, it's good that you mentioned that. I'm going to tackle this anti-competition law first. That's going through the Legislative Council. I'll relate a personal experience. I went to a supermarket last week, and I looked at a bottle of wine. They were selling one bottle for X number of dollars. If you bought two, then you would get a reduction, and you would then have a much better price if you bought two. So I said, well, that's a good deal. So I bought it, and that was in welcome. And then I went to ParknShop, and I saw exactly the same wine for exactly the same price. That is, people have been talking about the duopoly of the supermarkets, and that's a perfect example of how there is no competition.
You bring up very good points. First of all, as I explained, we do not deal with, the law does not regulate market structure. So the monopoly itself, or in Hong Kong, a franchise operation, if there is aspect of the operation that need to be dealt with by other legislation on non-competitive policy.
So what legislation deals with that?
What we're dealing with is really to allow the market to compare fairly. The example you just used about...
And it applies not just to wine, but a lot of other products have the same thing.
That's the...
You can buy a Campbell's soup or whatever, it's exactly the same price.
That's the matter right now. Right now, the existing law, we do not have investigation power because we don't have a competition bill, precisely why we're introducing the competition bill at this time, to allow the competition commission, that the body that we propose to set up, to have that investigative power. Now, without investigation, one cannot draw a conclusion whether any market practice is anti-competitive. So any example given right now without the benefit of investigation and facts finding would not be possible.
Okay, so tell me this. Sorry, go on.
So therefore, the law right now, as proposed, would have a competition commission vested with the power of investigation, require people to provide information or documents so that they could look at the practice itself and decide whether that's anti-competitive.
So this commission that will be set up under this law, competition law, will have the power to investigate such things.
Right. Right now, it's
But if
it's
they
all
go
on a
into the
voluntary
supermarket
basis
and they see that this is happening, what can they do?
There are many ways how the commission, as we now propose, the procedure to start investigation. It has to have a reasonable cause to suspect that there is an anti-competitive conduct has happened, is happening or about to happen, and then they could do investigation. Now, they could start the investigation on a complaint, and the consumer can make a complaint, and the government and the court could also refer any matter for the commission to investigate. Of course, the commission itself they have the power to initiate an investigation.
Is it going to be a toothless tiger, or will it have real powers?
It has prosecution power. Now, the commission can start the court proceeding, and under the proposed bill would have a body called Competition Tribunal. They are a superior court of record, staff of court of first instance judge, and they would decide on each case that would be brought forward by the competition commission. So the competition commission would have the power to start, so they would not be a toothless tiger.
I think, Mr. So, I think what people will ask themselves, and I'm asked, what you've just told me, I'm asking myself this: you have a competition law, and then you have a commission that oversees it, and it's got prosecuting powers. It can investigate things and start legal proceedings. Is a simple question: will this lead to consumers getting more choices? Because that's what it's all about.
You're exactly right. Competition law is really because the market is more efficient by competition, the price may reduce, the choices
You see that happening,
many.
Mr. So?
Well, that's why we're proposing the law, to foster more
So can we see a time when the market is not dominated by Welcome and Parking Shop?
As I said in the beginning, we do not regulate market structure per se. Where we're dealing with anti-competitive conduct, if any undertaking or businesses engage in this anti-competitive conduct, the law will catch it.
But then, it doesn't make any sense if you say you won't address the issue of market structure, and then you have this competition law. But then the thing is, how does one link to the other?
When I start off, I introduce the concept of abuse of substantial market power.
You don't encourage.
Now, for example, you have predatory pricing practice by someone with substantial market power. Of course, for example, they're charging a prolonged period of time of the price under cost, for example, and driving out the competitor. That would be abuse of substantial market power. You see what I mean? We don't regulate the mere possession of the market share.
How do you encourage competition? How do you encourage competition if the legislation is not aimed at targeting monopolies? If monopolies remain, then there is no competition.
Well, but the barrier entry into the market, if it's low enough, if the market is there, people will enter. But if there's an abuse of substantial market power and then people cannot enter into the market to compete, of course we will have to deal with that. But we encourage the market to compete, and that's why the purpose of the competition bill.
You know, I think one of the things that people are not very happy about, I know legislators are not very happy about, is that the government has excluded itself in that the government is not subject to this law, competition law, but the government obviously is a competitor in the market on many things. It sells land to property developers. Now, I'm not, sorry, go ahead.
Now, Michael, we're dealing with anti-competitive conduct here. And in any other international jurisdiction with a competition law regime, we're dealing with what they call an undertaking, which is a body that would be engaging in economic activities. Now, government invariably, by and large, do not engage in economic activities, so it makes sense.
In Hong Kong it does. It owns housing estates. It's the biggest landowner. It sells land.
Well, we also, the government provide essential public services. So we have to strike a balance because the government invariably would not be, engaging in this.
Okay.
And when we start the competition law regime, the focus should be on the private sector to deal with anti-competitive conduct.
Okay, let's look at the private sector. Forget the government for a moment. Let's look at the private sector. One of the things is competition law is not going to cover. I don't think that it's going to be able to deal with, for example, property development. We have in Hong Kong a handful of very large super developers. They control the market. That's a monopoly.
Now, the government, as you know, has recently introduced 9 measures. They deal with first sale of uncompleted properties.
Those are not laws. They're just voluntary regulations.
We are already witnessing, a change in the practice and positive changes.
Property prices have not dropped, Mr. So. They're going up.
Now, we have to allow for these practices, these 9 new measures to consolidate and to see how effective they are. And, we got to give them time. So the government will consider if these measures are not effective to use legislative means to regulate.
Okay. Well, we'll pick it up after the break. See you soon. Don't go away.